This is Paul Hitchcock, and asset protection planning is a real thing. If you own rental income property, a business, stocks, bonds, or cash, or you advise others who do, then you're going to want to understand asset protection planning. There's 40 million lawsuits filed in the United States every year, and it's only getting worse. It's a growth industry. Asset protection is the process of guarding all of your assets before something happens, when the seas are calm, and this is guarding against an unforeseen liability. I recently sat down with top asset protection attorney David Calderon, where he breaks down exactly what asset protection is and how to guard assets like property and other assets from an unforeseen liability. So let's go jump in to Wealth Protector TV. Hi, everybody. This is Paul Hitchcock. I'm with Barth Calderon. I'm here with Steve Williams from Fried & Williams and my colleague David Calderon. And I'm really excited to have you here. Appreciate it. We know everybody's busy. And this is going to be a very, very informative workshop today. Steve is a founding partner with Fried & Williams. We'll be getting into tenant-landlord issues. And David is a partner with Barth Calderon. And we're going to start off first here, and we want to make this very interactive. If you have questions along the way, feel free to put them in chat. We'll also open it up at the end for Q&A, but David is one of our top speakers. We're an asset protection, estate planning, and business planning firm. Been around for 30 years, member of SFAA, love the organization. I'm a local guy, live in Marin County, and have been to in-person meetings over there at the Fort Mason area, so love it. And Steve also is local here in town, a top landlord firm, and one of the top speakers for his firm as well. Does a lot of speaking to groups like SFAA and others. So David, we want to jump in to start here with asset protection, specifically for property owners. And I think a good place to start is what does asset protection mean? If you could define that, you know, especially for property owners, but how should people think about asset protection?
People should think about asset protection as another form of insurance, basically, against liability for their assets. Everybody thinks, well, I've got a lot of insurance, which is great, by the way. We always counsel clients to get as much insurance as possible. But insurance contains, usually your insurance policy looks like a phone book. And it contains a whole bunch of exclusions and things that aren't covered, things the insurance company won't be there for you to help you with. So in terms of property, asset protection is there as a way of helping to fill in the cracks that are contained within your insurance policy. And it's just using perfectly legal, perfectly acceptable strategies in order to shield both yourself and your property from liability, be it either liabilities that arise from ownership of property, like tenants or vendors or people that come onto the, guests that come onto the property, or personal liability that you may have that may somehow get your property roped into other things that are not related to the property. So asset protection is, in a nutshell, using perfectly legal structures, legal approaches to shield your assets from liability to the fullest extent possible.
Now, before we get into the nuance of some of that, because I do have some questions around the insurance issue and then getting into sort of the legal structures and execution of putting asset protection into place, but is asset protection a problem? Because we get this a lot from people, we hear it a lot, that, and I know you've talked a lot about it, is why do I need it? You know, why can I just hold a property, for example, in my name? So the landscape for asset protection, it is a deal today. You talk about, 40 million lawsuits in the U.S., many of those towards landlords, but can you describe a bit the landscape, for asset protection? I know you've litigated some stuff. So what's going on there?
Yeah, the more and more lawsuits get filed every day. Landlords are seen as kind of easy targets. I know government entities, be it cities, counties, at state level, a lot of times are very hostile to landlords, put a lot of burden on them, make things onerous for them to do business. So the landscape for landlords out there is hostile, and people are especially in this day and age coming out of COVID, everything else, people are looking for ways to get out of paying rent or to hold their landlords hostage for problems that may be present in the property, that sort of thing. So the landscape is difficult. It's a difficult environment for all of you guys to navigate. And asset protection interplayed with your insurance, I think, is essential to property ownership and property management these days. Unfortunately, if you have your asset in your own name or it's in a living trust, a living trust, by the way, provides zero asset protection benefits. Estate plans and trusts are simply there to administrate your affairs in the event that you pass away. Basically, it's just a document that says, I want this thing to go to this person, that thing to go to that person. Provides you with no asset protection whatsoever in your typical revocable living trust scenario. So, and having it in your own name just exposes your property to all sorts of issues, be it by way of creditors that you have could look to your property to satisfy debts and possibly judgments if you get sued. And conversely, your tenants could do the same if they get a judgment that's in excess of policy limits or not covered. They could try to liquidate your assets. And let's face it, property in California is usually almost always appreciating. We'll see how that goes as the Fed continues to hike interest rates to combat inflation. But property is always an asset that is even in depreciating cycles doesn't appreciate too much, and then eventually it comes back around. So people see that as an easy asset to try to liquidate, in addition to cash or things that are seen as low-hanging fruit for potential creditors and folks that want to do you harm.
Yeah, and so with the property, talk a lot about the fact that one of the biggest hurdles that we have as a firm when talking to property owners is really getting them to believe that something will ever happen to them, and none of us ever want to think a liability, especially a devastating liability, is going to come our way. But this is where we communicate, you're running a business when you own property. And if you had a corporation selling widgets, you wouldn't own that in your own name. You'd have a proper legal structure for it. But property seems, David, to be a case where people don't treat it all the time like a business. And so they'll own it in their own name. And so so this gets into, where does liability come from? Knock on wood, you don't ever have to deal with it. But if liability comes your way, it's coming from inside liabilities, outside liabilities, cases like mold. Steve, we did a talk with you not too long ago about a big mold case that hit a landlord, multi-million-dollar case. So David, can you talk about where liability can come from, inside versus outside, before we get into some of the...
Yeah, I touched on it a little bit, and I've got a great story of an example of a case that I'm working on in terms of right now trying to resolve for a client who has way too little insurance and way too much exposure and has gotten sued. But, basically, like I said, as I touched on a little bit earlier, inside liability are situations where liability happens, or you're exposed to liability from actually operations of the business asset. For, like, you have a rental property, then it's things you're exposed to because of the asset or the operation. It's tenant issues, it's issues involving guests. Like Paul mentioned, mold is one, and that's one insurance companies like to try to insure around. Basically, if there's an LLC that's properly formed, properly maintained, that can provide inside liability protection in terms of the operation of the business. Outside liability or debts and obligations that you have, creditors that you have personally that could possibly affect the business. So it's stuff that's coming in from the outside, not like tenants coming in from above, but other obligations that you have. Maybe you have other rental properties. You've got issues regarding those things. Other obligations, other debts that you've incurred, other liabilities that don't directly affect the property, but could be used by somebody else if not properly protected satisfy a judgment or an obligation against you.
Yeah, and that's interesting. The outside liability, a case that recently came through the firm was a real estate agent in the Bay Area, San Francisco, who sold a very expensive house, and then something with the floors went wrong, and she was sued personally uh, for that issue. And her and her husband owned rental property. He actually owned a business. They were looking at his business, the stock in his business. So that was a case in point of something unrelated to the rental property, but getting attacked because of a liability somewhere else.
Yeah, and it's very much, in a corporation, even if you form a corporation, you put your property in the corporation, it has a shield against inside liability, but it's not going to protect you from outside liability, from people that are outside coming in trying to foreclose on a judgment. They could foreclose on your corporation. An LLC, they're not able to do that. They have what's known as charging order protection, which means that if someone gets a judgment and they try to enforce it against you by looking to the assets of your LLC, all they can get is a charging order that entitles them to distributions of money from distributions in general from the LLC. They can't necessarily go in and foreclose on the ownership rights of the LLC. And there are things you can do to minimize the distributions and money that's taken out of the LLC and that sort of thing to try to work around judgments. But it's a very, very, very important distinction. And corporations do not have charging order protection per se, like LLCs do. And if I can go into the story.
Yeah, please.
I've got a current client who makes a lot of money, a high net worth individual who owns a portfolio of very expensive real estate here in Southern California. His wife was driving their daughter to school in the minivan, what have you, and needed some gas. So took a detour, made a left turn to go into a gas station, and ended up colliding with somebody on a motorcycle. And the person on the motorcycle ended up paralyzed basically from the thoracic part of the spine.
Oh, God.
So that person is now a paraplegic and has damages well in excess of the insurance policy limits that the clients have. And so in that case, we've done, some of the properties has been separate properties, a lot of it's community. There's a whole bunch of issues that are intermingled in there. But now, he's in litigation because of an accident that occurred with his wife, and trying to defend off a creditor on a case that's got 100% liability for the wife, but exposure way in excess of the insurance policy. So we're in the process of trying at this point in time to work on a settlement with that. We have a mediation in a few weeks to try to handle that. But it's a situation where, asset protection really heavily comes into play because the one big way we have trying to drive down that settlement demand, which is very, very, very extreme, is to talk about the asset protection structure that's in place, how the assets are protected, and how it's going to be incredibly difficult, if not next to impossible, for the plaintiff to collect in that case. So, the conversation's not, oh my God, I'm going to have to liquidate all this stuff because he's got a straight arrow to try to get it. It's now, what can I do to minimize the exposure I have and keep the focus on the insurance that's available, for example, to make up the bulk of any settlement proceeds.
Well, incredible story. I mean, that's painful for everybody involved there.
Totally, yes. And it's not discounting the person on the motorcycle who has been affected by the accident, but this person is the husband who didn't cause the accident. Like I said, is a high net worth earner. They have a family of their own, and so they're trying to manage it in a way that's fair all the way around. So,
what happens there, David? So in that case, I mean, you want it to be fair. Obviously, fair is not having one party bankrupted in a soup kitchen, but they get an attorney, who works on contingent and then comes after them and starts looking at all the assets they own in that scenario, they can just, everything's fair game. Is that right?
Everything is fair game in terms of they can put the dots together in terms of what the asset protection structure looks like. Yes. So in a lot of those cases, these attorneys, before they even take on the case, will do an asset search on the potential defendants to see what's out there, especially after they hear what the insurance limits are and if there's exposure that possibly exceeds that, So
would insurance even cover this woman in that scenario?
It does. No, the insurance covers it. It's just the insurance policy is just way too low.
Right.
The insurance company is willing to offer their policy limits to get rid of it, but the other side is looking for contribution from the wife and also the husband. To kind of pay into whatever is going to be paid to sell that case. So, they're aware of the other side's aware of some of the assets, but they're not aware of everything. And, it's our job to educate them as to look, you should focus on what's there and take what's there, because if you're going to go after the other stuff, it's going to be a very, very, very difficult, road to hoe for them. So.
Yeah. And this gets into a properly built and maintained limited liability company, because, we know it's so easy to go out there and set one up today. I mean, you go on LegalZoom and bang one out for $150, but the issue is what you're talking about now is if nothing ever happens, it's almost like earthquake insurance on your house. If there's no earthquake and you don't need your earthquake insurance, if you have lousy insurance, you didn't pay your premiums, who cares? You didn't need the insurance. Asset protection is like this. If nothing ever happens, great, you win if you have a crappy LLC. But if something happens, that thing's got to work. And it's going to be tested. And so let's talk about the LLC and the important decisions that go into setting up an LLC to make sure that it would work when it's needed. What are some of the components of the LLC?
Well, just to digress a little bit. I mean, I can't tell you how many LegalZoom or LLCs we see after the fact, where people have paid their $500, whatever LegalZoom charges them for the LLC, and they get it filed to get an operating agreement, but then they don't do anything with it. Either they don't transfer the property into the LLC, or they just don't take care of the very minimal formalities you need to do the LLC and keep it active in California. So, those are all things that need to be taken care of, and all things that a full service law firm will give you, as opposed to, say, a LegalZoom or somebody like that, where you kind of get what you pay for, right? And I have to fix those quite a bit. Those come across my desk. But the components, like you said, basically you file your articles of organization with state. You get an operating agreement that basically provides the ground rules for the operation of the LLC. And then you need to transfer your property actually into the LLC, deed it over to the LLC. So it's owned by the LLC and not you. The thing is, you would be the owner of the LLC. You would be the member, or if it's husband and wife, maybe husband and wife are the members of the LLC, or whoever is invested in the property, that sort of thing. So you would still own the LLC, but technically the LLC stands on its own. And what we usually, for maximum asset protection purposes, we usually often or advise clients to set up what we call foreign LLCs, which are LLCs in another state, like Nevada, Alaska, South Dakota, and then you simply register the LLC in California to do business here.
So even though your rental's in California, you don't need to have a California only LLC.
Correct, and because California provides charging order protection for LLCs, but up to a point. At a certain point, California could still possibly foreclose on the economic interest in the LLC, which is the right to receive income from the LLC. Not necessarily ownership of the LLC, but the right to receive income, right? Foreclose on the economic benefits. Whereas
other states don't have that.
Like the ones I mentioned, Wyoming, Nevada, for example, or Wyoming, especially, the charging order remedy is the only remedy. Basically, it's like a lien. So they don't get any economic interest. They don't get any ownership interest. What they get is a lien on things. And like I said, if you're registered in California, maintain it here. California law, a lot of times will honor, they will honor the Wyoming LLC or the Nevada LLC, and you can look to their laws in terms of how to deal with the asset in terms of foreclosing it or getting a charging order or whatever. And a lot of times landlords are hesitant because of cost. They look at the cost going in. I mean, Wyoming's incredibly cheap to maintain an LLC there. It's like $60 a year to do it. In California, it's $800, right?
Yeah, right.
That cost is way more than offset usually by the amount of rental income you're going to receive annually from a property, and it's just an added layer of insurance, and it's basically kind of the smart and savvy thing to do.
Yeah. So it's picking the right jurisdiction when you set it up. And then how about single member versus multi-member? Is there a discussion there that you typically have with folks?
Yeah, multi-member is usually more preferable because courts are less likely to foreclose on an LLC that has multiple members as opposed to single member, especially in California. If you have a single member LLCs in California are not really recognized here. So a court will look at that as quote unquote, or look at the LLC as the alter ego of the owner, right?
Really?
Basically, yeah, a lot of times. So they will do that. If you have multiple members and it's just a straight California LLC, then it's difficult to argue that. So because control is vested in more than one person. But if you go to Wyoming, go to Nevada, go to Delaware, single member LLCs are recognized and perfectly fine. You don't have to have multiple members there. But in California, I would never do a single member LLC.
Interesting. So, and in California, a multi-member could be husband and wife, or, if you don't have a spouse, it could be 99% you give a percent to your kid or something like that.
Correct. It could be parent-child. It could be husband-wife. It could be, any person that you deem worthy of having an interest in the LLC.
Very interesting. And then you get into the operating agreement, because when you set up an LLC, you don't have to have an operating agreement that you create, correct? But if you don't, are you subject to the off-the-shelf operating agreement of the state where the LLC is?
Yeah, you're subject to the laws of the state where the LLC is located. So the limited liability company laws. And I would never, especially in the case of a multi-member LLC, we'll put it this way, even a single member, I wouldn't, I would have an operating agreement that's available, because you never know. You may end up gifting or selling a percentage of that LLC in the future. But also, with multiple members, an operating agreement basically is the ground rules for operation and management of the LLC, right?
Right.
So you want to have a set of ground rules there that if a dispute arises, something happens, you could point to and say, hey, look, the operating agreement says, says we deal with this way, that sort of thing. And also too, it's evidence that you're operating the limited liability company not as an alter ego, but as its own, own entity that stands on its own 2 feet, separate and apart from you.
And with the living trust, it's not an either or. You have a living trust or an LLC. How do those integrate with each other?
Yeah, and first of all, I would recommend that everybody on this call, get a living trust. Basically, take care of their estate planning, right? Because you never know when something's going to happen to you, and I think you'd rather control who your assets go to than a judge. So, I would think that everybody here at a minimum should have an estate plan. And as far as an LLC is concerned, basically, what you would do if you have an estate plan, oftentimes, if it's something you choose to do, is that you would simply assign the ownership interest that you have in your LLC over to the trust. So that way, if something happens to you, then the trust can dictate how your ownership in the LLC is going to be distributed amongst your heirs, be it your kids or friends or a charity or that's your spouse, that sort of thing. So they basically work hand in hand that way in terms of just the post-incident or death distribution. But the one thing, again, I'll emphasize is that a living trust does not do, a revocable one, is, give you any sort of asset protection, because you still have full control over a revocable trust. You can revoke it, amend it, take things out, put things in, that sort of thing.
Okay.
And control and asset protection is a big thing.
Okay. And yeah, I want to cover kind of as we hit the end here, we'll transfer over to Steve, is a couple of questions that came in ahead of time as people knew we were doing this workshop. One is on the reassessment issue. So we got a couple questions around this. One is, we had somebody ask, okay, if you move your property from owning it in your own name or joint with your spouse or a business partner into an LLC, is it going to be reassessed for property tax purposes?
It should not be reassessed if it's just basically kind of if the LLC ownership strata, however, whatever the setup of the ownership of the LLC is, if the property ownership mirrors that and is transferred into the LLC, then no, you should not be reassessed.
Okay, done right. And then last question, Prop 19. I know that that's a whole different discussion, but for families who are trying to keep property, from generation to generation, Prop 19 is an issue. Now, we had the head of the Howard Jarvis Foundation speak to our firm about a month ago. They're trying to overturn Prop 19. It was very informative discussion he gave to us, but there are ways to build around Prop 19 now and get some ownership from the LLC to your kids. Can you just mention that real quick?
Yeah, we're still at the fallout from Prop 19, and without getting too far into the weeds politically, I guess it's like a lot of laws in California, AB 5, whatever. It's like it's well intended, but it has a lot of unintended consequences that kind of follow it, right? And so, in this case, the law is still fleshing out in terms of Prop 19 and what the ramifications are going to be. So, but there are things that we can do with LLCs, with trusts, that try to do a workaround around Prop 19 to pass property down without it being reassessed pursuant to the law that's come about as a result of Prop 19. So there are things we can do, but a lot of that stuff is still in its infancy. So as soon, as that develops, like any other law, and it gets challenged or you end up in court and judges interpret it, we're still going to see a lot of flux in that area in terms of Prop 19. But there are ways that we can try to plan around it if you consult with us to do so.
Okay, wonderful. David, thank you. And I've got to say, that's the headquarter office there in your background, and that light on up in that corner office. That's you at night because you're slaving away every single night up there. I'm sure it is.
Exactly.
Yeah. Thank you very much. That's great. And I want to let everybody know, I'm going to put up in the chat there my email. If you're interested in getting one-on-one with David, we always get questions and start thinking about these things. Happy to give you complimentary input on your own situation, on anything, estate planning, the asset protection, LLC input, Prop 19. So put my email there. Feel free to shoot me an email, get you connected with David, and happy to do so. Steve, you want to take over? Thank you, David.
Sure. I just had a follow-up question for David on that bike accident case, the unfortunate case.
Yeah.
Actually handling. Let's say the couple owned a rental property here in San Francisco, and they owned it individually instead of in an LLC, in some sort of asset protection format or entity. Would that rental property in San Francisco be at risk in that motorcycle accident case? And if so, what could happen to that property?
Yeah, I guess it all depends on what kind of planning you've done ahead of time, right? Which kind of gets into the weeds. Maybe if it's,
let's say they own individually instead of in an entity.
Like individually, oh, they owned it themselves.
Yeah.
Oh, that's getting liquidated. That is.
So the injured
Yep.
biker could sue and force the sale and get the proceeds from that.
Correct. If they just own it in their own names or community property or that sort of thing, yes. Then it's part of the pot that can be used to satisfy a judgment.
I'll sing it louder.